So, I think it was a lot what I would call serendipity. There were various things which were happening around the financial banking ecosystem, and happenstance Rahul Mathan, partner at Trilegal and somebody who's working quite a lot on DPI, reached out and for some technical piece of discussion on banking product. And from there, actually, we started collaborating quite a lot. I think my first sort of contribution to the DPI block was around SciGem, and that was really facilitating loans being taken by those that have supplied to government enterprises through the GEM system. And the creation of those terms and conditions which were to facilitate all of those loan transactions became my first insight into the DPI world. And the tiny bit of contribution was really framing, as I said, the terms and conditions governing that process. If I had to sort of put it, maybe legal frameworks tend to sort of not be noticed when things are going very well. Usually everybody sort of looks at their legal rights, obligations when things start to go wrong. But it's important to keep those frameworks in mind as we are building anything new and making sure that people do sort of have their rights, obligations, responsibilities, liabilities laid out in equal measure. I think that has been sort of the contribution, if at all, that I have been able to make in some parts. I will break it out maybe into 2 or 3 components. I think the first primary thing which any DPI seeks to do when it's facilitating commerce, facilitating business and so on, is that there is a contractual nexus or a contractual framework that comes for all parties involved. So, creating and reimagining these contractual frameworks was something that like I mentioned, I could contribute in SciGem, but it went on to how the Sehmati ecosystem for account aggregators is crafted and so on. And I think it's important for lawyers and those working on these ecosystems and the DPI to always factor in what that legal framework should look like. So, in any ecosystem, if it is open architecture, does the contract also form as and when anybody new comes in and automatically with everybody else in the ecosystem, or is it going to be bilateral with each party and that adds to friction, that adds to time, that adds to cost. So, the approach we took was in a way borrowing from how countries negotiate multilateral treaties, let's say between multiple countries on a same subject matter, and they deposit these instruments which they have signed up for with the UN Secretariat, so as to speak, for it to become operational. To us, it was that can we create a framework which has defined each party's roles very well, whether in terms of rights, obligations, responsibilities, liabilities, and it is uniform. So, if I am always going to be a lender, it does not matter whether that lender is A, B or C, they will always have the same obligations, same set of rights. If I am somebody who is going to provide some data, my role will be always to provide data in a predefined fashion. So, as long as one can conceive of everybody involved in that ecosystem and what their obligations and rights are, you can create such a framework. And like I said, it should be open architecture, it should allow people to enter and be immediately be in a contractual nexus with everybody else without having to replicate or do that bilaterally. I think the main aspect was stripping down to the bare minimum of what we thought everybody's obligations or rights needed to be. We wanted to equally say that it should be fair to everybody in the ecosystem. Typically in any contract, contractual framework, the minute a lawyer or anybody reads it, you can make out who was a stronger party and who was a weaker party, who had a stronger bargaining position and who had a weaker bargaining position. And I think those reflect in many contracts that one sees. In a DPI context, I think our thing was that it should be fair to everybody who joins in the ecosystem, who joins because of that DPI initiative. So one, there was fairness, which was a key sort of thing for everybody involved. The second, as I said, that because you are in a stronger bargaining position, you usually ask for 5 more things. Maybe those are good to have, maybe those are what give that stronger party a comfort and so on. But is it really required for what is the service to be done or the product that is to be delivered? And if the answer is no, then we would sort of remove it from such a framework altogether. So it comes down to being, I would say, going back to basics, going back to what are fundamentally required and those that are fair. And that's how one constructed such contractual frameworks. A lot of it got shaped with what I call, the protocols that exist in the technology world. So if we had to think about that, computers can talk to each other because there is TCP IP. That protocol, as long as one computer has, kept, it will allow it to talk to another. And I think that drove the kind of framework that I described, that anybody can sign up and be automatically linked to everybody else. So in a way, it becomes a network that you are signing into and not a bilateral set of documents or agreements with everybody else. And like I said, bilateral tends to add cost, friction, time, and the bargaining position sort of reflect in the contract that is actually arrived at. Whereas in such a multilateral approach, in such a network approach, I think we drew a lot from how technology principles, like I said, of protocols are to arrive at this. So they were. I think anything which you create as legal document which is going to be used or applied by hundreds of people, hundreds of banks, NBFCs, or for that matter, fintechs and other parties to the ecosystem, each one comes with its view of what it thinks its contract should look like. I think explaining that we have actually reduced everything to the fundamental requirement of what is needed to be done and that it is fair. I think that was the biggest convincing part, if you will, which we had to do with everybody. That they weren't going to lose out, that nobody else was going to get an upper hand, that they were not being placed at a disadvantage. I think all of that needed some time of convincing and getting people to understand. And as they understood it, I think they came on board and made it a reality, so as to speak. I think some big institutions endorsing it upfront also gave it the endorsement that it required. But equally, the hungrier players also sort of saw the benefit of it and signed up quickly. So I would say it's a bit of both, which sort of overcame the stumbling block. But it can easily could have been more strenuous and more challenging. We used it for several DPI initiatives, and the critical portion was what kept us honest and what kept these terms identical to the technology was that the protocols, if tested for that particular DPI, would have shown exactly what was put in the terms as well. So the explanation and the documentation was matching what the technologists had sort of created. If that was not in sync, people would have immediately sort of noticed and said, on the terms you have said this, but actually the platform or the protocol is behaving differently. So there was a lot of cohesion with the people developing that platform, those protocols, to make sure that we were committing and we were staying honest to those protocols. In DPI, anyway, these things also sort of get documented and uploaded into GitHub or other repositories for people being able to backtest and validate. So I think that is what would have also shown that you can have trust in what was documented and put out as terms. I think two sort of big takeaways for me. One, that you can indeed strip down a contract to its basics for what is the actual service needed to be done. I think otherwise, you know, that one has more rights, more obligations, more things to sort of document. Always made more sense. But I think as I confronted the DPI world, you realize that you needed only so much and not more. To do what you are setting out to do. So I think that was one big takeaway for me. The second big takeaway at whatever level was being able to sit in everybody's shoes. So hitherto I had always worked with a commercial enterprise, and the only thing you looked out in contracts was for that commercial enterprise's position. You wanted to protect its rights, its obligations, its liabilities and so on. I think when you work on DPI, you suddenly realize everybody who's sitting on the table or will be part of it and looking through their shoes, their eyes, and crafting something which is fair for them. So that to me was the biggest, sort of takeaway, apart from, as I said, bringing things down to fundamental fair level. This was the second big sort of thing. I would put it in two sort of buckets. For a layperson, there should be a ease of understanding, and I think there is what I call the plain language drafting, which means it should be as it should make sense to you as much as it makes sense to me when I am drafting something, and that a layperson can read it, I think, is the bigger sort of objective to be achieved. So I think people who are creating such things should make it simple, easy for people to digest, to be able to understand. Amongst the things as a layperson that you will think about is, okay, what happens if it doesn't go through? And that's why I said the dispute resolution, grievance redressal becomes an important component. What happens to the data after I have parted with it? So then a portion which talks about, okay, this is how your data will be handled. If we are not giving you what you want, we will destroy this data. If we are giving you what you want, it is now going to be part of our records, and we might reach out to you for 1, 2 and 3. I think that explains how your data is going to be handled. The further things are there other points of interaction? Can you reach out to a call number, a call center number? Do you reach out over email? Do you reach out over the same protocol that you formed a relationship via? I think those again become things which you should, as a layperson, become aware of and know. And I am saying, think of it as simple as, let's say, beacon protocol, which is enabled, Namma Yatri. And if that rickshaw driver does turn up, there is a fulfillment of what was expected. What if the person doesn't turn up? That is where the dispute begins, or that's where you want redress. You paid him something, but that payment was extra, so he should have refunded. He did not. What happens next? I think just anticipating each of these and being able to address them is what I think a layperson would require. For a lawyer, my advice would be, like I said, my biggest learnings are what I would wish for them to have, which is being able to imagine contracts just to the extent that is required. It's the equivalent of how in manufacturing one talks about just-in-time manufacturing. There is no pile-up of inventory, there is no extra, dependency on storage, warehouse. You are exactly using what you needed to do something. And similarly, contract drafting can sort of be that. And the second, like I said, being able to imagine everybody else's position and being fair to them and not trying to take advantage of any one view or position. I think that those are the two pieces which I would want lawyers to also take away. When we think about what goes on into any DPI, any transaction supported by DPI and so on. I mentioned contractual framework, I talked about dispute resolution. I think there is an intermediate step of what I call discovery, of what I call guidance or advisory, And with today's tools which we have, I think it's again fairly easy to provide. So I think of the equivalent of chatbots which can reference the underlying documents and give easy to digest answers to people who might have questions. Instead of them having to read through 5 pages, 50 pages of that document, being able to provide that answer through a chatbot which is focused on that document and also past questions, past answers, I think will be a dramatic sort of addition to DPI. I also know of people who have harnessed the ChatGPT and sort of said, okay, we will load up all this into ChatGPT and get it to generate the answers for us. I think that's the second level of what again DPI can sort of do. And if you want to then overcome the language barriers amongst all of this, I think again DPI has shown whether through Bhashini or other protocols that you can actually even transcend the language barriers and translate it into any number of languages that are required, whether through text or whether through voice. And all of these, I would say, should become almost what every DPI construct should carry. It may begin at a more fundamental level, but I think the building blocks should allow it adding all of these and making it more inclusive, making it more focused on what can even be explainers before people enter into the transaction. Or even if you have doubts during a transaction period, you may want to say, what happens if, and it should be able to give you that answer. My belief is they already exist, it's that we need to bring them together, and that is where we can sort of all help. In terms of threat, I think technology always keeps evolving. I think all of what we have kept and adopted also needs to evolve. It is always said that there is a version 1 and then there is a version 1.1, 1.2 and so on, until you move to the next level, which is probably version 2 and version 3. I think as a lawyer, as somebody who's contributed to the legal side of DPI, I would say the legal framework also needs to keep pace with what is going on. I'm speaking both of the broader legal framework outside of the DPI, but the contracts and the dispute resolution also needs to move apace. If they don't, we will have a breakdown both of trust, of ability to do transactions, of what that infrastructure was built for. So I view that as the threat. I think good ecosystem players recognize it, and I think everybody wants to make sure that the version movement is again fair and equitable for everybody involved, and lessons from what has been going on are taken forward and applied also. There are 2 or 3 things to consider. One is that the contractual framework has to be grounded in the legal system in the way that normally business does business in that country. If there are things which, like I mentioned, are good to have but not necessary for a product or a service being delivered, dropping them early on is better. Because those things then become challenged when people are signing into the DPI system. So keep it essential, keep it fundamental, keep it fair, I think would sort of be first piece of advice. The second is that test for where will it break down. Test for what will you say that when it breaks down. Will you have some sort of dispute resolution, grievance redressal, etc. built in. I think India as a country has also sort of adopted, which I was going to come to next, which is not just a contractual framework, but a dispute resolution that is true to the digital public infrastructure, namely in form of what is called online dispute resolution or ODR. And I think many of the DPI success will also be how fast and how properly do you resolve the grievances, how properly do you resolve the disputes that arise. And indeed, if rest of the things are digital, maybe the resolution also needs to be online and digital. So I think these two go hand in hand, and Again, India has taken the first few brave, bold steps. So I'm hoping people see that in the context that not only do you need a proper contractual framework, you need a dispute resolution framework also, and both can be digital. The opportunities in India are demonstrative for the rest of the world that indeed if you have created the basic DPI, whether it is identity, whether it is payments, whether it is assurance functions which can ride on these frameworks, you can make more and more complex blocks for addressing what people require. If you envision it from the start of saying, yes, any business activity requires a contractual framework, you begin to think on those lines. We have taken it to the second or third layer of complexity, beginning from where we were to where we have reached. And of course, we still have lots more to traverse, but this is what I would sort of advise the globe. And I wish all of them to sort of take our lessons and take the good lessons and apply them. Thank you.